Good morning. Lovely to see you all today. Really nice to be back after the summer break. We thought that we would spend today looking at some of the cases that we have seen that have flown from the COVID pandemic. So we're beginning to see them now come through the tribunals, and even a couple that have reached the EAT that were from early on in the pandemic. And in particular, we thought it'd be useful because actually we can start to draw some themes from the way the tribunals have considered and reached decisions in the cases, and so hopefully help in tackling some of the issues that we're seeing now with more staff returning to work, and obviously the issues that are arising out of changing working patterns. So if we just flick on to the next slide, Amy. I'm going to start off, we're covering 8 cases in total in fairly high speed fashion. I'm going to start off with a general medley, looking at a couple of the discrimination type claims and refusal to obey reasonable management instructions. And then Joe's going to pick up the cases that are all to do with automatically unfair dismissal for an individual having raised health and safety concerns, an area that we've seen quite a lot of. And as Amy said, we're going to finish off with plenty of time for Q&A as well. So the first case I'm going to look at is around pregnancy. So Mrs. Prosser, who was a pregnant employee of the Community Gateway Association, they undertook a pregnancy risk assessment. You're probably aware that you need to do that for all your members of staff anyway, and sent her home rather than work. They also then delayed her return to work because they had ordered perspex screens and they were still yet to come. I think something that many employers have experienced. So the demand, who knew there'd be a demand for such things, but a demand for perspex screens, and they were also undertaking a reorganisation of the desks in the office, so in order to manage better social distancing. She obviously felt sidelined, vulnerable, and that she was not able to work when she wanted to work. And so she brought a claim. Probably you'll be relieved to know that the tribunal did not support her case that she'd been discriminated against on the grounds of her pregnancy and had been victimised. Of course, all of these cases, there's always a compounding factor, and that she'd been paid properly all the way through, but there'd been a delay in the payment that was completely unrelated to either COVID or the pregnancy. But of course, that wasn't her perception. So those of you who know me will know that I love getting involved in the pregnancy cases, and we've discussed them many times over these webinars, and they're still proving to be an area where we're getting a lot of queries, and it's perhaps challenging. So what can we glean from this case? I think what was really helpful was that the tribunal were really supportive of the employer in that they were following the government guidance of the time and their own risk assessment. So I would say in all of your cases where you're dealing with staff who may not agree, or where you're making some difficult decisions, make sure that you are complying with the guidance, keep a copy of it, and also critically speak to your member of staff and communicate with them that has clearly gone wrong in this case. Understand their perspective, make sure that they understand your perspective. The tribunal was absolutely satisfied that in this case the employer was trying to protect Mrs. Prosser and her unborn baby, and that was their motivation. And so make sure that you're explaining that as well. You may well have seen the latest guidance from the government around pregnancy. It's in July. We can include a link to that in the follow-up as well. But if you're dealing with pregnancy cases, I would definitely recommend that you read that. It's still perhaps challenging for employers because it acknowledges that in the 3rd trimester, so past the 28-week mark, actually there is still greater risk to pregnant employees, and so advocates following social distancing guidelines that may be in place. Of course, we haven't got any in place at the moment, so there's a bit of an odd gap there, and also recommends that employers work flexibly as far as possible to allow employees to work from home. Now, that won't always be possible, but there's a clear message that in that third trimester, or where there are underlying factors that increase the risk to pregnant employees, you should be trying to accommodate that. And obviously, if you can't manage the risks satisfactorily, then the default position when individuals are pregnant is that if you can't manage the health and safety risks, they should be suspended on full pay during that period of time. I would say I think it's an area where you don't want to be too bullish or robust. I'm generally fairly robust in my view of how to manage issues, but actually, given that this is a relatively short period, the third trimester of somebody's pregnancy, and it's clear that there are increased risks, I would advocate caution and following the guidance, so allowing home working as far as you can, where that's something that an employee wants and it's backed up to manage the risks. I'm going to move on to a completely different topic now, a case involving Mr. Ham. If you can flick on to the next one. Mr. Ham was employed as a cleaner. This dates back to the early days of the pandemic. He was required to deliver equipment to his manager's home. His manager was self-isolating with COVID symptoms, and Mr. Ham refused, citing that he was concerned about his own health and safety and that of his family. He was dismissed as a result. The reason for the employer was that he hadn't obeyed a reasonable instruction. They were obviously, you can imagine, challenging times. This was back in March 2020. That they didn't realise that they were asking him to do something that was risky, and actually they needed to continue to provide their services, and that they thought he was just being difficult in refusing to obey an instruction here. It's one of these cases that Joe's going to look at in more detail as well, where he didn't have 2 years service, and so he did not have protection from ordinary unfair dismissal. But the tribunal found, perhaps unsurprisingly, in this case, that his dismissal was automatically unfair, that he was raising legitimate concerns around health and safety in this case. And they could have found an alternative, and in fact he suggested some alternatives around, a different drop-off point. It seems fairly obvious when we look at this case now, with the benefit of what we know in sort of September 2021, but I think it's illustrative of the fact that things are changing all the time, and so it's important to always sort of understand an individual's perspective. I think be flexible in this case, and whilst generally you'd be used to saying, well, we can manage our work as we want to, and actually we can set out reasonable instructions. I think we are in a slightly different landscape with COVID, in particular, where people have genuine concerns about their health and safety, which requires you to manage it a bit more carefully. As I say, Joe's going to pick up on some of these, the themes from these cases in a bit more detail after this. My third case is another discriminatory one. This is an interesting case because actually it doesn't arise from COVID. The circumstances that I'm going to talk to you happened in 2018, but it's about the requirement to work in the office rather than home. So when you think about what you're probably wrestling with at the moment, and the questions that we are getting around, to what extent you can require people to be back at work, to what extent you have to allow flexible working, hybrid working arrangements, and how you ensure that that's continuing to deliver the services that you need and want. The issues in this case are really pertinent to that. Mrs. Fellows was employed by Nationwide. She was a senior lending manager. She had predominantly worked on a contract that was home-based, although she came into the office 2 to 3 times a week. The reason she was home-based particularly was that she cared for her disabled mother, and that was known to Nationwide, although there were other people as well employed in the same role who also worked from home, who didn't have those particular personal circumstances. Nationwide carried out a review. They needed to reduce headcount, but they also wanted their senior lending managers to be based in the office to supervise more junior staff. And that was based on feedback that they'd had from the junior staff, as well as sort of the management view that it would make for better teamwork and supervision in the workplace. They went through their process. They offered the opportunity to for voluntary redundancy. Mrs. Follows did not choose that. She wanted to remain at work, albeit she said that she couldn't be based permanently in the office, and so she was ultimately dismissed. She brought the claim for direct and indirect disability discrimination. Now, remember, she wasn't disabled herself, she was caring for her disabled mother. The direct discrimination claim failed, in part because actually this rule applied to everybody and there were other comparable people who were treated in the same way. So she wasn't treated in this way because she was a carer. But her indirect claim succeeded. And that was on the basis that the tribunal found actually the requirement to be office-based all the time, and the requirement to be office-based did have an adverse impact. It was more difficult for those with disabilities or those associated with those with disabilities to achieve. And so Mrs. Follows was protected by reason of her association and the caring responsibilities she had for her disabled mother. And that meant, because this was indirectly discriminatory, that Nationwide had to objectively justify their decision. And that's about having a legitimate aim and ensuring that it's proportionate. And the tribunal was quite critical, perhaps surprisingly. Said that the legitimate aim of being in the office all the time wasn't borne out in this case because they didn't have any evidence. It was just based on a subjective view of the management at the time, and they hadn't particularly looked at Mrs. Follows, her experience in supervising, whether anybody had had any difficulties with her supervising remotely in the past. They also felt that proper consideration hadn't been given to other alternatives or flexibility, so whether it could continue being part at home and part at work in order to achieve the aim as well. So she succeeded in her claim. So I think it is an interesting one, and although it's only at the first instance, so it's not a binding precedent, it probably is a useful guide in terms of things that you need to think about. We all know that people have very strong views about working patterns at the moment and whether to work, whether working from home is more effective, whether working in the office. And there are people who have views on either side of the equation. In fact, we've seen in the press, some national significant businesses have come out very strongly in favour of both of those options, with some basically saying everybody needs to be back at work all the time in the workplace for that collegiality, and others saying, absolutely not. People can choose to work whenever, wherever they want, and everything in between. And so actually in this case, I suppose it's really important that just a person's subjective view is not the reason for it, that you do need to listen to people's views. You need to consider personal circumstances, and if you are going to make a robust decision, that you have got some evidence to back up your reasoning. So hopefully that's quite helpful. And my final case, probably more straightforward actually, Cubilius and Kent Foods Limited. Mr. Cubilius was a delivery driver for Kent Foods. One of the rules in their employment handbook stated that customer instructions regarding PPE requirements must always be followed, and that it was important to maintain good relationships with customers. Mr. Cubilius, driving his lorry, refused to wear a mask when he went to Tate and Lyle. He remained in the cab of his lorry, but obviously he was elevated. He had the window open in order to manage his delivery. The staff at Tate and Lyle complained. They were concerned about him, passing on germs through the open window, particularly given his elevated position. Tate and Lyle fed that back to Kent Foods. They were unhappy. They basically banned him from attending their site unless he would wear a mask. And so as a result, Kent Foods dismissed him for failing, really. They considered the fact that he hadn't adhered to the customer requirements, that he damaged the relationship with a really important customer. It was relevant to them that he wasn't going to change, so he basically refused to accept that he could be required to wear a mask in his private cab, given that the law didn't necessarily require that. It was also relevant that actually the fact that he couldn't then go to Tate and Lyle meant that he couldn't do his job, and that created practical and logistical difficulties for them. So probably it was a very good result for most employers that that decision was supported at first instance again by the employment tribunal. I suppose the reason that I thought it was interesting was that it was in May 2020, so it's quite a different landscape perhaps to the wearing of face masks than we have got now. And many employers I know, as part of their risk assessment, are still requiring the wearing of face masks in certain circumstances and in particular situations, and that must be reasonable. But you can see that we will see some cases where employees say, hold on, the government guidance doesn't require it, it's not a legal requirement, I'm not going to do it. And will it be reasonable in those circumstances for an employer to dismiss based on the fact that either their own or another third party customer or contractor relationship requires it? I think I would say that we will have to continue to keep an eye out, but with all of these cases, it's understanding with an individual before making a decision what their reasons are, can they be overcome, are there any other alternatives or ways forward before just reaching a decision. But hopefully they are some quite useful themes. Happy to take questions at the end. I'm going to hand over to Jo now.
Thanks, Alice. Good morning, everyone. As Alice mentioned, I'm going to take you through several cases involving COVID-related unfair dismissal claims. These are automatic unfair dismissal claims related to health and safety issues and concerns. So these claims arise under Section 100 of the Employment Rights Act. And this section, together with Section 44, provides protection for individuals who are dismissed or subject to a detriment raising health and safety concerns in the workplace. It's a day one right, so there's no requirement for any qualifying service. So employees who have been with an employer for only a short period of time are entitled and eligible to raise these claims. So prior to the pandemic, these provisions were rarely relied on. It wasn't something that we advised on day in, day out. And they've received a great deal of attention over the last 18 months for obvious reasons. And we're now starting to see first instance decisions from the employment tribunal filtering through where employees have raised issues and refused to attend work due to concerns about the risk of contracting COVID in their workplace. So the cases I'm going to go through aren't binding decisions, they're just first instance decisions from the employment tribunal, but they do provide some helpful guidance on interpretation of these provisions in the context of COVID. So as a bit of a recap about Section 100, it protects employees by providing that dismissal is automatically unfair, where the reason or principal reason for the dismissal is that in circumstances of danger, which the employee reasonably believed to be serious and imminent, or which he could not reasonably have been expected to avert, he left or proposed to leave or refused to return to his place of work while that danger persisted. It also renders a dismissal automatically unfair in circumstances of danger, which the employee reasonably believed to be serious and imminent, where he took or proposed to take appropriate steps to protect himself or other persons from danger. So those are the two elements of Section 100 that have been relied on in a COVID context. The rollout of the vaccination programme and relaxation of restrictions has perhaps undermined the arguments around workplaces presenting serious and imminent danger to health and safety from COVID. However, there will still be certain circumstances where these claims would be advanced. So thinking about individuals who can't or won't be vaccinated, who may be at higher risk of becoming seriously unwell, or those who live with others who are clinically vulnerable or extremely vulnerable. You could see circumstances where they would still rely on these provisions. In addition to automatic unfair dismissal, action short of dismissal can amount to a detriment, and detriment under Section 44 of the Employment Rights Act is something that employees are protected from experiencing. So up until May this year, that right was only a right that was reserved for employees, but from May onwards, that has been changed so that workers are also protected from experiencing a detriment, raising health and safety concerns. And one final thing to add around this is that compensation is potentially uncapped in relation to these claims. So it's significant and a significant financial liability, potentially, if an unfair dismissal claim is successful. So if we can move on to the next slide, please, Amy. The first case I'm going to talk about is Rogers and Leeds laser cutting. So this case explored the issue of whether it was reasonable for the employee, Mr. Rogers, to believe that there was a serious or imminent danger from his workplace, and whether removing himself from work was an appropriate action to protect his family. So the particular facts here, Mr. Rogers messaged his manager to state that he would be staying away from work until after the lockdown was eased. He said that the reason for this was because he was worried about infecting his children who were vulnerable. He had a baby and a small child with sickle cell anemia. He was very worried about the impact of COVID if they were to contract it. A month later, Mr. Rogers was dismissed and he brought claims under Section 101D and E of the Employment Rights Act. His evidence during the course of those proceedings was quite vague and contradictory. It was accepted that he worked in a large warehouse. There was a lot of space between workers. There were only 5 of them in that particular area, and that his employer had taken reasonable steps to put in COVID secure measures and had been mindful of making sure that staff were protected as far as possible from the transmission of COVID. And in this particular case, the tribunal held that Mr. Rogers had been fairly dismissed. Whilst he had a reasonable belief that there was a serious and imminent danger from COVID, he hasn't established any link to his workplace. It was more of a general concern about COVID and the pandemic, rather than raising specific issues about his workplace and how that would affect health and safety. In addition to that, he had taken a friend to a hospital despite being advised to self-isolate, and he'd been working in a pub at that time. So it contradicted some of the arguments that he'd raised and undermined the strength of his case. If we move on to the next slide, this is the case of Gibson and Lothian Leisure. And it's quite an interesting contrast from the Rogers case, because here we've got Mr. Gibson, who was a chef. He was, or the restaurant he worked in was temporarily closed, like many similar organisations at the start of the pandemic, and he was furloughed. And in advance of the restaurant reopening, he was contacted by his manager to come back to work to help out, and he raised some concerns about the health and safety of the environment in the kitchen that he was going to work in. Whereas in Rogers, the employer had taken lots of steps to try and make the workplace as safe as possible and to limit the transmission of COVID. In this case of Gibson, the employer had done absolutely nothing. There wasn't anything around wearing PPE. They hadn't put in place any steps to protect staff. There was no social distancing. And Mr. Gibson raised specific concerns about the lack of PPE. And when he refused to attend work, he was essentially told to shut up and get on with it. And then his employment was terminated by a text message at the end of May, just as the restaurant was about to reopen. So he brought a claim for automatic unfair dismissal under Section 100. And the tribunal concluded that he had been automatically unfairly dismissed. There were clear circumstances of danger. There was the growing prevalence of COVID-19 infection at that time. There was a peak rising. And he had specific concerns that his father, who he lived with, would be at particular risk if he caught COVID and passed it on to his father. And so removing himself from the workplace was an appropriate step to prevent that transmission and prevent serious and imminent harm to his father. And the fact that his employer hadn't taken any steps around PPE and around protection was a key factor in that decision too. So if we move on to the next case, and this is Catatus and Fortuna Group. So in this case, Mr. Catatus worked for a company that sold and distributed PPE equipment. Obviously, at the time of the pandemic, the services and the products of this company were in high demand. All staff were considered to be key workers, and it was all hands to the pump situation. Everyone was expected to be working, and it wasn't a business that was looking to rely on the furlough scheme, for example, because there wasn't any sort of cessation in the work that they were doing, and they were really busy. Fortuna had taken steps to put in place measures to protect their staff. They put in extra cleaning. They had taken steps towards social distancing and were mindful of the need to protect their staff. So around late March, so at the very beginning of the pandemic, this is in 2020, Mr. Catatus requested to work from home. But his request was denied by Fortuna. They looked at his request, but the type of work that he was doing wasn't work that was naturally suited to working from home. He was involved in accepting daily deliveries, entering information into the company systems, logging orders, and all things that needed really to be done on site. And so his request was refused. But the company did have in place a policy that allowed staff to take paid or unpaid leave if they didn't want to be in work. On the 30th of March, Mr. Catatus contracted symptoms of COVID, and he was advised to self-isolate, which he did. And after several weeks, he was still experiencing some symptoms, and he made a request to Fortuna to see if he could be furloughed. And his request was considered. He was told, because the company wasn't engaging with the scheme and didn't feel that it was appropriate for them to do so, because they weren't impacted by COVID and continued to trade, his request was denied. Mr. Catatus went back to the company and said that he wasn't comfortable about returning to work. He raised a concern about using public transport, and he also suggested that whilst he was on SSP, he was going to be financially penalised, and he again asked to work from home or to be furloughed. And he raised, he'd done some research on the furlough scheme, and he'd suggested that Fortuna could rely on it, despite the fact that they were trading, they were busy. His requests were again denied, and after several exchanges with his employer, he was dismissed at the end of April, and the reason given was a general ongoing failure on his part over a period of months to support and comply with the company's policies and guidelines. Mr. Catatus didn't have sufficient service to bring a standard unfair dismissal claim, so he brought an unfair dismissal, automatic unfair dismissal claim under Section 100, asserting that his request for furlough or to work from home were appropriate steps to prevent the risk around serious and imminent danger. And the employment tribunal considered his arguments, and they found in favour of Fortuna. They found that he hadn't been unfairly dismissed. It did accept that he had a reasonable belief that there was an imminent danger from COVID-19, but what they assessed was that his request to be furloughed or to work from home wasn't an appropriate step to protect himself from the danger he'd identified. They concluded that there were economic reasons why he'd made a request for those particular measures to be put in place. He didn't want to have any financial impact of not going into work. And so rather than taking that first line step of removing himself from work to protect himself, what he was actually asking for was to be paid while away from work, even though it would be very difficult for him to, or for the company, to get the benefit of his services from home, because it wasn't a natural fit. So it's quite an interesting case, on the basis that perhaps if Mr. Catatus had brought it under section 101D about refusing to work, it might have had a slightly different outcome. It was the fact that there was that financial security that he was looking for that meant that it wasn't considered an appropriate step to prevent the danger that he had identified. So quite an interesting decision from the tribunal, and quite a thoughtful one in terms of how his position had impacted his employer and all the steps his employer had taken to try and create a safe working environment. If I could move on to the next slide, please. Thanks, Amy. The final health and safety case that I'm going to look at is the case of Mononaro and Landsafe. So Mr. Mononaro was on holiday in Italy at the start of the pandemic in lockdown 1, and he was obviously concerned about travelling back and the risks that proposed to him. So he asked his employer for advice. He asked for instructions and assistance with documentation, and he was willing and prepared to work remotely in his role until it became clearer what implications there would be for travelling back and whether he'd be able to get back safely. He didn't receive much communication from his employer at all. He was sort of left in the dark about what would happen, and then his employer informed him that he was going to be summarily dismissed for failing to follow instructions and procedures and taking unauthorised leave. So he brought a claim in the Employment Tribunal under Section 100, and he was saying that he was taking appropriate steps to prevent the health and safety risk that he perceived he would experience from trying to get back from Italy at that point, and that working from home was an appropriate option in the circumstances. And the tribunal found in his favour. They found that there were circumstances of danger, given the declaration of the pandemic, the risk of catching a contagious virus that could lead to really serious health implications and potentially death, and that limiting his travel but still being available to work were appropriate steps in the circumstances to prevent that risk or to reduce that risk, and that his employer had been acted unfairly, and that his dismissal was automatically unfair. So the string of cases, there are only a few of them at the moment, but it's quite interesting the subtle differences between them. And although they relate to the early days of the pandemic, and things have certainly changed a lot since then in terms of the vaccination rollouts and also established practices within workplaces for social distancing and COVID-safe measures that are still going on, even though there has been relaxation of the rules and guidance and mandatory requirements. It does show certain themes, though, that mindful employers who are taking health and safety carefully, who are taking steps to carry out risk assessments and to make sure that their staff are as safe as they possibly can, are in a much better place in arguing that it's not a reasonable belief around imminent danger, serious danger. And those who have been mindful of that have come out of these Section 100 claims in a much better position than others, like Lloyd and Leisure, who didn't take any steps at all. So that brings me to the end of the cases that I wanted to cover. And we've got some time for questions, and we've got a few questions that have come in. but please do add them to the Q&A box if you've got any more that you'd like to ask either me or Alice. So if I have a quick look.
Hi, Jo. Do you want me to start off and chip in? The first question, I don't know how much, is about tips for employers in care homes and the recent change in legislation around the vaccine with the deadline, and any advice around that. So for those of you who are not aware, the government have legislated to require that anybody who works in a care home cannot enter the care home after the 11th of November. Unless they have been double vaccinated or subject to some fairly limited exemptions. It's quite an interesting development, really, because it's the first time in the UK that we've ever had mandatory vaccinations, although there was ongoing consultation about extending that to other social care and other sectors potentially. So yeah, you should have, if you're a care home employer, it's obviously really significant change. You should have written to all your employees, and you should ensure that you've got evidence that they've all been double jabbed, otherwise they won't be able to enter the home. If you have got people who are just sort of shortly awaiting their second jab because they're young or because they have been overseas or whatever, then obviously I would recommend that they can't go in after the 11th of November, but you might look at what alternative options are. If there are people who are not going to be jabbed, then clearly you need to think carefully about whether they're still able to do their job or not, and make clear to them what the potential consequences are. The exemptions are pretty limited. There are exemptions, obviously, for friends and family, so they don't apply to friends or family visiting residents, although they still must adhere to any other risk measures that you've got in place. It doesn't apply to under 18s. It doesn't apply to emergency services or for people attending in emergencies, although you need to be careful not to abuse that, or for urgent maintenance. And there are again some examples, but again that's not normal maintenance. It would only be, say, that if there was a really significant leak or a boiler blew up or something like that, you have to respond to. Probably the most significant exemption that will be relied on is for those that are clinically exempt, and that's probably and that's a difficult area. We have just seen, I think it was last week, there was a letter that was issued which essentially gives a link to allow people to self-certify for a 12-week period if they believe they fall within the clinical exemption. So if you've not got that letter, drop me or Jo a line and we can then send you a link to that. The intention is that then there will be an NHS COVID pass, which requires a formal medical exemption. And so it will only be those individuals who have either got this 12-week maximum self-certification and then the formal medical exemption through the COVID pass who will be able to enter into the care homes. And you do need to be careful. I mean, actually, it will be a breach of the law to allow any visiting professionals or anybody to come in. So even you couldn't do job interviews in the residential bit or have hairdressers come in or anything like that unless they've properly been double jabbed or have this specific exemption. So hopefully that answers that question, but let us know if you need anything more specific. Jo, should I pick up? I don't know if there's anything you want to add to that. I can pick up the one about the maternity guidance, and then do you want to pick up the next? So the next question was the details of the government guidance I referred to in the first maternity case. We'll send a link around with the follow-up, but essentially it's dated July 2021, and it's the government guidance around pregnant workers, and so I would say it's essential reading. It's only short. It refers to into the Royal College of Obstetricians and Gynecology as well, but it sets out, it distinguishes between those in the earlier stages of their pregnancy and those in the later stages, and so we'll send the link around to that.
If I pick up the next question then, so the question is, in a school environment, is it reasonable to take the general view that support staff are required to be in school rather than to work from home, as they generally support the teachers who are in school teaching? Appreciate there might be exceptions which may be dealt with under flexible working policy. So in general, if you can support your decision for staff to come back into school, and it has a sensible rationale, like you say, supporting teachers who are working, then it is reasonable. With anything, you need to make sure that there's a legitimate aim to it, and that it's proportionate. And on a case-by-case basis, if you have individuals who raise particular concerns because of their own health or their own concerns about people who they may live with, other reasons why coming into school is difficult for them, then those need to be discussed. There needs to be good communication with them. And if there are particular issues, that those are addressed. But in general, a requirement to return to work, if it can be supported, is a reasonable thing. I don't know if you wanted to add anything else to that, Alice.
Oh no, I completely agree with that. I think now that the presumption is that employers are able to return back to working as normal, really. But yeah, I agree with you. I think if individuals raise issues, look at what you might be able to do to support them or accommodate them on a case-by-case basis. And actually, the old guidance was things like looking at how they got to work and the flexing the start and end time, thinking about whether they might not need to attend, say, whole staff meetings in person or go into a closed office space. So I'd still recommend that you talk to individuals with concerns and put those specific adjustments in place. But generally, yeah, I think you can require the norm being back in at work and supporting it, subject to those ones where there may be a discriminatory element that you need to be more careful. And if you're really stuck, I think going to get some occupational health advice about an individual's particular personal circumstances and what you need to do to manage the risks for them is the way forward.
And of course, the request might not be COVID related at all. It may be that actually working from home has worked better for that individual. And as the person raising the question mentioned, it could simply be a flexible working request, which would need to be dealt with in line with the flexible working procedures, which it sounds like we're going to have an announcement tomorrow, might change in the forthcoming future, so that it may become a day one right, but that's something that's subject to consultation coming. So the next question we had: if an individual feels they are at risk of danger, does the employer need to show they've put measures in place or risk assessments, and therefore refusal to come to work could be considered unreasonable? So with any of these issues, the more that you've done to make the workplace safe and the more you can document it and evidence that you've done that, the more difficult it will be for the employee to have that reasonable belief that there was an imminent danger or serious risk of danger to them. But that I caveat that it's about the individual's personal circumstances and what they perceive to be a risk. So there would need to probably be that consultation with them, understanding from them what their concerns are, rather than it just being a blanket risk assessment and measures put in place. But certainly the more you can do to protect staff, the less weight their arguments around imminent danger will have.
Great. Should I pick up this final one about a flu jab in case anyone else get other questions? So the final question is: we have a flu jab program which we offer to all employees. Some staff feel that we should prioritise staff as a result of their medical conditions. Is it necessary? And the concern being flagged about collating medical information. An interesting question. I think we will see a take-up of flu jabs, increased take-up this year, perhaps. I think as long as it's being offered to everybody, there shouldn't be any need to prioritise or make judgments around who needs it first, because actually, if it's openly available to all, I suppose is the concern for employees that you might run out of slots or you might run out of options. But I think if you can ensure that everybody who wants a flu jab is going to get it, then you don't need to worry about that. I agree with you that there are lots of data protection issues with collecting sensitive medical data, and you probably don't want to be doing that really unless there's a very good reason to, and it doesn't seem necessary in this situation. And again, you wouldn't necessarily want to get involved in deciding who should have priority and not. I would say make sure that everybody's clear it's available to all. You could potentially, a pragmatic option would be to say, if people are really keen to have it done early, they can let you know and be prioritised. And so, if that's something that you're able to accommodate, but I agree with you, as long as there's no detriment. Jo, I don't think, is there anything else you think we've missed around that?
No, I don't think so. We've had just one more question come in. So the final question is, if an employee refused to return to the office in the knowledge that some colleagues haven't been vaccinated, nor do they intend to, would this be reasonable? I suppose my initial view would be around vaccination. The idea of vaccination is about protecting the individual rather than transmission. So if that particular individual had been vaccinated themselves, in terms of the serious and imminent risk, are they at serious and imminent risk would be one question, and it would be exploring that with them. Also, what does the work environment look like? Are they likely to be working in close proximity? Are there other measures in place to reduce potential transmission? And all of that would feed into whether their position was reasonable. And I think probably in this instance, probably unlikely to be reasonable, but we'd need to know more detail. Is there anything else you want to add to that, Alice?
No, I agree entirely. I think the government guidance is really clear that vaccination status at the moment is not part of the risk management process. So it's about putting other steps in place as well. And also, I think there's a general, people's vaccination status should not be shared with others widely in that instance. It may be reasonable for you to know, as if you're managing risk or ensuring that you need to, for staffing purposes, but you shouldn't be able to share it in that way. So no, I think it's about talking to them about how they can manage the risks in other ways. Absolutely. I think you can require them to return.